It's an honor for me to be able to introduce a gentleman that I've known for a long time. He's a good friend and certainly a person that I have great admiration for. As lawyers, we all appreciate the many responsibilities of the Attorney General. He is, of course, the Chief Law Enforcement Officer of the federal government. He's the legal advisor to the executive branch. And he has a special responsibility to the people of the country to be sure that the Constitution is preserved and protected. When the Attorney General is introduced, you know, it's always appropriate to say the Honorable Jeff Sessions. Well, with Jeff, this is not merely a protocol courtesy. With him, it is an accurate depiction of the man himself. And so, ladies and gentlemen, I ask you to join me in welcoming the truly Honorable Jeff Sessions.
It is really great to you, and thank you, General Meese, for those special words. But I just was thinking, you know, I should want to ask you, is Ambassador Kislyak in the room? Before I get started here. Any Russians? Anybody been to Russia? Got a cousin in Russia or something. So anyway, I was so honored to work for General Meese, and I was given the opportunity to hang certain AG pictures in my conference room, and you can be sure his went up in that room. And I worked for him, and I know the leadership he did, and they still remember, particularly the law enforcement community. We're part of law enforcement, if anybody wonders, and our duty is to protect America and have the back of our police officers. Police are the solution to the problem of crime, not the problem, and we need to know that. So there's no doubt, really, this is a historic thing. There's no doubt the Federalist Society has made an enormous and positive difference for our legal system. I cannot name one entity over the last 35 years, to my recollection, that has come close to the influence of the Federalist Society on a single important subject facing America. It's unbelievable, really, how much progress has been made. Your work has been the core of our relentless efforts to restore the rule of law in this great nation. And more than the rule of law, it's really the fundamental moral order of a created universe that's so ably advanced by our constitutional system. American people well know that activists, judges effectively invalidate votes. Unprincipled ideologues want unelected judges to do for them that which they cannot win at the ballot box. This is not a partisan question. It's a question of fairness and fidelity to the judicial oath and adhere to the constitutional role that's assigned to the judicial branch and to the other branches. Judicial activism puts the prejudices and politics of the judge above the law and makes him into a continuing constitutional convention. An activist judge sits in judgment not of the case, but of the law itself, it appears, really, deciding which laws to apply and which ones not to apply. Whatever it is that activists dispense, it's not law. Judicial activism is especially disturbing in our country because we have inherited and advanced the most magnificent legal system in the history of the world. Indeed, the Anglo-American system is one of the greatest achievements in civilization. We have the oldest existing constitution in the world. It's an achievement we've been blessed to inherit and that we've been able to advance. So many of you have helped advance it. It's one of the main reasons that America is exceptional. History teaches us that such a system of ours, such a legal order as ours, is precious. It's rare. I've traveled the world. I've seen how hard it is to pass out a constitution to an undeveloped country and expect them to be able to carry it out. It's fragile. Civilization is difficult to build, but sometimes easy to destroy. In his Lyceum address, Abraham Lincoln said, "If we accept the small violations of the rule of law, then these violations will only become more frequent and more serious, and if that happens, it will still instill in the people contempt for law and eventually for the Republic itself." At the Department of Justice, we are committed to preserving the people's respect for the law by carrying out the law fairly and impartially. Meanwhile, I've changed policies at the department that support our mission of doing justice by executing the law. For example, we are no longer allowing so-called sanctuary city jurisdictions to nullify federal immigration law if they want to receive discretionary grants. We have placed conditions on these grants to encourage our elected leaders of these states and cities to comply with minimal cooperative requirements to assist in removing criminal aliens from the country. In June, I ended the practice of third-party settlements. Under the last administration, the Justice Department often required settling parties to pay settlement funds to third-party organizations that were not directly involved in the litigation or harmed by the defendant's conduct. We believe that when the federal government settles a case against a corporate wrongdoer, any settlement funds should go first to the victims and then to the United States Treasury, not the bankroll. It's not the bankroll, third-party, special interest groups, or the political friends, or whoever is in power. Nowhere does the Constitution grant unelected attorneys, even DOJ, wonderful sainted attorneys, or political appointees, the power to effectively appropriate and distribute United States Treasury funds based on political alliances and friendships. Neither does it give them the power to issue regulations outside the process of Congress's regulatory authorities given by Congress. Too often, rather than going through the long, slow regulatory process provided in statute, agencies make new rules through guidance documents by simply sending out a letter. This cuts off the public from the regulatory process by skipping the required public hearings and comment periods, and it is simply not what these documents are for. Guidance documents should be used reasonably to explain existing law, not to change it or rewrite the law. From now on, at the Department of Justice, that's what we're going to do. I'm announcing today this process is over. So we prohibited all Department of Justice components from issuing any guidance that purports to impose new obligations on any party outside the executive branch. We will review and repeal existing guidance documents that violate this common sense principle. We will also now honor a directive that has been on the books at the Department of Justice since it was ordained by the man sitting in my right, Ed Meese, when he was Attorney General. I am ending regulation by litigation. The days of sue and settle, when special interests could sue an agency, then get the agency to agree to a settlement to impose, in effect, a new regulation to advance an agenda, is over. The Department of Justice is duty-bound to defend laws as they are written, regardless of whether or not the government likes the results. Our agencies must follow law. We're not entitled to make it. Judges in our courts must apply it. But as we know too well, some judges fail to respect Congress and the executive branch. One particularly striking example, it's a bit in my craw, I'll admit, was a federal judge in Brooklyn who heard arguments on a challenge to the federal government's wind down of the DACA. Outside the legal question, the court said to the government, to our government counsel, you can't come into court to espouse a position that is so heartless, close quote. Not unlawful, heartless. With respect, it is the province and duty of the court to say what the law is. I knew you'd get that. They are to apply and follow the law, not advance an ideology or express political beliefs. We cannot allow unelected judges to set policy through an abuse of the adjudicative process. Comments on policy like these from a judge are offensive. They unfairly criticize an attorney who is effectively doing his job. Judges have the solemn responsibility to examine the law impartially. We're going to resist this tendency resolutely. The judicial branch is a co-equal branch. It is not a superior or a policy-setting branch. It needs to know its role. Those who ignore this duty and seek to advance their own policy views erode the entire rule of law. They set bad precedents and, importantly, undermine public respect that's necessary for the courts to function properly. An increasing number of district courts are taking the dramatic step of issuing nationwide injunctions, orders that block the entire United States government from enforcing a statute or an executive branch policy or order nationwide. Scholars have not found a single example of any judge issuing this type of extreme remedy before the 1960s. Never contemplated, apparently, by our founders. But today, in effect, single judges are making themselves super legislatures for the entire United States. We have nearly 600 federal judges, district judges in America, each one with the ability to issue an overreaching nationwide executive order eroding the power of the President of the United States, for example. So the Supreme Court is consistently and repeatedly made clear that courts should limit relief to the parties before them. So if lower courts continue to ignore that precedent, then the Supreme Court should send them that message again. And joining the entire federal government is an extreme, dramatic step. To take that step because of a political agreement would absolutely be unacceptable. The Constitution gives judges no right to veto a president's actions because they disagree with him on policy grounds. So the media, by the way, let me note, only focuses, it seems, on decisions that go against the Department of Justice. But we also have some important wins. The Supreme Court has vacated both of the appellate court rulings against the president's travel pause. They're taking it on the merits, but they vacated the injunctions. We've also successfully obtained before the Second Circuit a rare mandamus order staying a premature and abusive discovery order in a case to stop the wind down of the DACA program. Just an overreach. And I don't know how many times you've seen a mandamus on discovery be granted, but this one was, and we appreciate the appellate court for doing so. And so, although some district courts have initially ruled against us, I'm confident our positions will be vindicated in the Court of Appeals and, if necessary, in the Supreme Court. The President Trump has the statutory authority to suspend immigration in the law of any individual or group of individuals he deems are contrary to the national interest. His rational, narrow proclamation of a pause from certain countries that are dysfunctional and provide risk is justified within his powers as the chief executive, who has the responsibility to protect the public interest, and we're proud to vigorously defend it. So before I conclude, let me say this. There are those in this room, and maybe more than a few in this room, who get frustrated about when they turn on the TV at night, you know, and you have to take Rolaids, and everybody's got an opinion about what the Attorney General should do or what somebody else should do. Well, I get frustrated too. A lot of things I'd like to be able to say and explain, but the rule of law isn't always about getting the outcome you seek. It's using the same fair process, pursuing the truth wherever it leads. We can never allow any part of our legal system, and least of all the Department of Justice, to be reduced to a tool for a political agenda. This department will not make decisions based on politics, ideology, bias, as long as I'm Attorney General. I believe that this is what the American people expect. I think this is what the American people expect and deserve from the Department of Justice. And we will not confirm investigations or leak sensitive law enforcement information to get a few cheap headlines. I am determined, we are determined as a team in the Department of Justice to reestablish proper discipline in these matters that has been eroded.